Good morning, everyone. So, am I audible to everyone? Fine. So, welcome to Let's Crack UPSC CSE English channel. So, very good morning to you all. I'm very happy to see you on daily, right? So, we are discussing very important concept, especially in polity. We are trying to make polity more interesting, and we are discussing the most important concepts. And you are getting the live classes and live tests. Please make use of it. These live tests, unlimited access, these structured courses I'm telling you will help you in a very long manner. And then you can download the Unacademy app using the Google Play and Apple Play Store. It's available on both the platforms. And about me, so I'm an engineer basically, and I have 4 years of teaching experience, and I have mentored more than 100 students, and I'm anthropology faculty too. So I have given you two specific topics for prelims, which I'm trying to make it easy for you to remember. Fine. So you are interacting with the top 100 educators, but how can you interact this? By getting the subscription. So these are the details of subscription fee. And do not forget to use my code SUBA because you will get a 10% of offer of your subscription fee. So now yesterday you could have seen they have released that UPSC have released the calendar for the next year. So people who are deciding to give my attempt, this is my new attempt, this is my first attempt, ma'am, like this is my first year, I am giving my attempt next year. In the sense, I think Iconic is the best thing where you have a personal coach. So personal coach and study planners, and then question answer session. So these are all their main question answer writing practice. These are all there, which are very important for the preparation process, which is strategically will make you more ready for the exam. Okay, so that's important. And plus or Iconic, you can use my code SUBA, so you get a 10% of discount of offer of whatever you are opting for, whatever course you are opting for. So this is my live class, and we will discuss there every evening from today onwards. I am planning to have a 7 to 9 session where we will completely discuss whatever is needed for this prelims. Fine, most important concept, the nook and corners, that is where the question comes from, not from the general content. The question comes from the nook and corner. I will search the nook and corner for you and we will discuss. Fine, so don't worry about it. So coming to the class, fundamental rights part 2. So yesterday we discussed few important concepts. So in that, under right to freedom, we were discussing article 22. So today what I'm going to do is I'm going to give you a short revision of article 22 and some important concepts that we haven't discussed yesterday. We'll be discussing now, and then we'll be going to right against exploitation and right to freedom. Fine. So under protection against arrest and detention, Article 22, very important. What is the difference between Article 20 and Article 22? Do you all remember yesterday I told you the difference? Yes, Article 20 is a person has been arrested and brought to court. So when he is brought to court, when he is being convicted for his offense, conviction means confirming that he is the one who committed the crime and giving him the proper punishment is called as conviction. So Article 20 deals with you have been brought to court and then the conviction takes place. But Article 22 is related to when you get arrested. When arrested and before taking to a court, before taking to court. Before taking to court. Okay, so when article 20 is after taking to court, article 22 is before taking to court. Okay, this you should keep it in mind. Okay, in many movies you would have watched, first they will arrest a person and then take to the custody, they will file the FIR, and then within 24 hours they should be produced before a magistrate, and that magistrate should grant the permission for further detainment. If not, that person should be released within 24 hours. So these two articles deals with that. Just imagine what will happen if these two articles are not there. Okay, so the atrocities by the the protection department will be very high. Fine. Next, so this article 22, as I told you, has two parts. The first part is related to ordinary cases and second part is related to preventive detention. So Article 20 deals with punitive detention. This is also important. Punitive detention. Article 22 deals with preventive detention. So preventive detention means it's a type of precautionary measure to prevent some crime to happen. Okay, so it's like, you know, expecting it. The police department will expect that that person might commit a crime, heinous crime. So to prevent that, they take him into preventive detention. Okay, so we'll see about preventive detention, all these things. So the first part is why a person has been arrested. You know, under ordinary law. Generally, ordinary law is general arrest. So when a person is arrested, what happens is that first of all, he should be informed why he is being arrested. He should be informed why he is being arrested. Second is that he should be allowed to contact his lawyer, okay, legal practitioner. He should be allowed to contact his lawyer, and then he should be brought before any magistrate within 24 hours. In that, journey time is also included. So including journey time, 24 hours, within 24 hours, the person has to be person has to be produced before any magistrate. If that magistrate is not authorizing further detention, that person has to be released within 24 hours. Okay, so this is how it works. The second part, okay, so in this ordinary law, yesterday we saw, in this ordinary law doesn't mean civil laws. Usually criminal laws is what they are talking about. Okay, civil law and then related to tax, deportation of aliens do not come under this concept. Only, criminal laws come under this concept. Okay, usually in movies you could have watched, you know, when they come for income tax rate, they just disconnect they just disconnect all the calls. Okay, all the mobile phones, all the contacts. So if a person is having this article 22 for income tax also, he might, you know, try to escape from the hold of government, so that, you know, when they, the failure to pay income tax will not come under this article 22. Fine. Next. Good morning. Yeah, one by one people are joining. Yes, so we'll go to the second part. Yesterday we just saw the first part. This is second part, which speaks about punitive detention, sorry, preventive detention. Second part is about preventive detention. So this preventive detention is available for both citizen as well as alien, whereas the first thing here, you know, here it is, the article 20 is available for friendly aliens and citizens. Here punitive detention, the preventive detention is available for both citizen as well as aliens. Fine. Next. What are all the conditions? Preventive detention cannot exceed 3 months. So, a person is arrested because it has been anticipated that he might commit a heinous crime. So, he has been arrested. Till how long he can be kept under preventive detention is should not exceed 3 months. Okay, so unless and until there is an advisory board's reports, advisory board has given the reports for the extended detention. Okay, they think that okay, 3 months is not enough. Some advisory board is giving a report that this person has to be there inside inside the detention. Otherwise, when we are leaving him outside, he might commit the crime. However, so who is this board? The board should consist of judges of High Court. So I told you an advisory board should give the report. Who is that board is? The board should contain, the board should contain judges of High Court. Okay, fine. So what are all the rights for preventive detention? First of all, the ground of detention should be communicated to the detainee, that is who has been detained. However, sometimes if it is against the public interest, it need not be disclosed. But for ordinary law, we saw that, that is the first part. In first part, we saw that. Okay, so I'll tell you how preventive detention and national security law. See, the simple thing about preventive detention, I'm coming again, do not worry, please listen to me carefully. Preventive detention means there is a person, so let's take person 1. So there's a person, so P1, so he's a known criminal or anyone. It's not just he must have a criminal record or anything. There is a person. So police is anticipating that this person might commit a crime. Okay, there is proof that he might commit a crime. In that situation, there is the possibility, there is power for the police to arrest this person, okay, without even committing the crime. Okay, this is an anticipation, this is an expectation that it's a guess that that person might commit a crime, and he can be arrested, and he can be kept under the control of, that is detention. Okay, he can be kept under the control, detention can be done. Number one. Number two is that he should not be kept beyond 3 months. He should not be under detention beyond 3 months. Okay, number one. Next is, if there is any proof given by, if there is any report given by an advisory board that 3 months is not enough, maybe he should be under detention for even more months. An advisory board should give the report. Who is that advisory board? They are judges, judges of High Court. Okay, so this preventive detention is not rare. Many cases of preventive detention has been there, especially when there are these important dates. You know, there are certain important dates. It varies from state to state, maybe sometime throughout a country. Sometimes when there is some one more reason is like when there is any landmark judgment of Supreme Court related to some, related to some sensitive issue, and in that situation also the police can take police can take action to prevent these crimes. They arrest certain peoples under the concept of preventive detention. Okay, so preventive detention is generally to prevent some crime to happen, a heinous crime to happen. Okay, so they cannot arrest everyone. There should be a proper reason. You can see here, the grounds of detention should be communicated to the person who has been detained, but there is one more thing, is like if it is against the public interest, it need not be disclosed. Okay, and the detainee should be offered and should be afforded an opportunity to make representation against the detention order. Okay, okay, person has been arrested. Will he be there without having any other rights? He can talk to his lawyer and make a representation to cancel that preventive detention. That has to be afforded. That opportunity has to be afforded. Fine. So these are the cases. These are the important acts, important laws which are giving power for preventive detention. First is Preventive Detention Act of 1950, but later what happened? It was expired in 1969. Next is Maintenance of Internal Security Act, then it was repealed in 1978. Conservation of Foreign Exchange and Prevention of Smuggling Acts, so it is there 1972, Conservation of Foreign Exchange and Prevention of Smuggling Activities, that is there. National Security Act, NASA, so 1980, so under National Security Act, the thing is, if there is any assumption, or if there is any proof that there is a person who is threat to national security, that person can be preventively detained. Okay, without even committing the crime, he can be detained. And then Prevention of Black Marketing and Maintenance of Supplies Essential, so Commodities Act, that is also there. And then Terrorist and Disruptive Activities Prevention, TADA, so it was repealed in 1995. Fine. Next, fine. Next is unlawful activities, as someone asked, UAPA, Unlawful Activities Prevention Act. See, the act itself has the term prevention. Okay, it has been amended in 2004, 2008, 2012 and 2019. Okay, so this act is also there. Don't worry, we'll be discussing in detail with these kind of amendments, important amendments. And then Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act, Prevention of Terrorism Act POTA, which has been repealed in 2004. Because you can see some acts have been repealed. Why was, this act has been used, some acts have been used in an immoral way by the authorities to take personal revenge on people, or to commit some crimes, to prevent some crimes that some authorities have committed to coming out. So since these act, even though we have fundamental rights, these act are like preventing the fundamental rights, basic fundamental rights reaching the citizens. So these kind of atrocities sometimes have been repealed, but there are certain acts still now which has been having the power for preventive detention. Fine. Repeal means removed. Simple. Repealed is removed. Removed is or cancelled or strike down. Okay. Next. But it is very unfortunate to know that no democratic country is having the preventive detention. Okay. So we are democratic nations. But no country is having preventive detention, but India is having preventive detention. Okay. So that is one important thing that we should know, because it's unknown in USA. So USA, we know democracy. USA is, presidential democracy, but they don't have it. But since, Britain was having it, and we were, we followed 1935 Act, and then many of the Britain's method of governance was followed by us, we still have it. Even after independence, India is continuing this preventive detention. Okay. So you might get question in prelims related to which articles deals with preventive detention, or it means they can ask you about, your comment on preventive detention, whether it is right or not, all these things. So when there is a question which is asked related to whether preventive detention is ethically right or preventive detention is constitutionally right, it is constitutionally right. Yes, we do have it in constitution, but the thing is that you have to speak about the plus and minus. Sometime I told you it has been used for committing atrocities against the citizens, so in that situation it's a negative. But in some situation we know there is a person who will commit a crime outside, instead of waiting till the person is committing a crime, why not arrest him or arrest her before committing a crime? Okay. So it has its own pros and cons. So you have to write accordingly and give a conclusion. So conclusion must be right, must be like, you can say that, though preventive detention is having some setbacks, when they are properly regulated, it can serve as a best mechanism to prevent many kinds of crime in our nation. Okay, so these kind of positive way of thinking, the proper regulation can be done, or overcoming the feedbacks, overcoming the setbacks can be done. These kind of answers should be given. Fine. No, that's what I'm saying. In terms of criminal, see, keep it in mind. One person have asked me, that is called as ex post facto law. So ex post facto law means no retrospective effect. Ex post facto, which is no retrospective effect. So if there is any repealed cases, they will not consider this. Okay, that is what you're asking, ma'am. If there is a person who has committed crime in 1990, but this Tada Act has been repealed in 1995 only, so what they will do is, it has been repealed. It's not in the constitution. It's not in the law, so it won't be used. Currently, what is the problem? They will take it. Currently, what is the rule? They will take it. Okay. See, simply keep one thing in mind. The judiciary will go to extreme punishment only in certain situation. Okay, so keep that in mind. No person, every time judiciary or government will try to save the citizen, they won't have any intention to punish the citizen. So if there is a citizen who is getting punished for his crime, because that person should not be an example for others, that is the only reason. It is not just, he has done a mistake and he should be committed. Judiciary or constitution has not been written in such a way. It's either a reformation process, or making other citizen understand what will happen if there is any crime committed. Okay, so keep this thing in mind. Fine. Next, right against exploitation. So what is this right against exploitation? So till now we saw article 20, article 19, so sorry, article 19 to 22 is related to right to freedom. Okay, so now we are seeing two important articles which is related to right against exploitation. So what is this right against exploitation? Fine. So in right against exploitation, we have two articles, article 23 and 24. What is article 23? So in article 23, they prohibit traffic in human beings, begar means forced labor, and sometimes they are called as bonded labor also, and the other similar form of forced labors. Okay, so this right is available for both citizens and non-citizens. Fine. So this is very important. This right is available for both citizens and non-citizens, and then it protects individual not only against the state. So till now, when we were seeing all the rights, it was either it was between citizen and state. So most of the rights were to prevent state taking advantage over the citizen, or to prevent the state being aggressive over the citizen. But this right, prohibition of traffic in human beings, is preventing the citizen from state and also from other people. Okay, and also from other people. So it is protecting the citizen from both state and individuals. So that is one thing related to this prohibition of traffic in human beings and forced labor. Okay, next. The expression traffic in human beings include. So according to Article 23, so what does this traffic in human beings include? First is selling and buying of women, children, and men, women and children like goods. So it's not just women and children, men are also included. Men, women and children like goods, number one. Number two is immoral traffic in women and children, including prostitution. Okay, forced prostitution and then immoral traffic in women and children also comes under this articles. And then Devdasi system. Okay, so Devdasi system is also under this. Fine. So Devdasi system means, in religious places. Okay, especially what they'll do is they'll give girls to the temples. Okay, so Devdasi, Deva means God, Dasi means slave. Okay, so Devdasi means they are considered as the slave of God. So what they do is they perform some art performances. Okay, but what happened was there were exploitation by the religious persons on these Devdasis. So this Article 23 is prohibiting this Devdasi slavery. Fine. So in according to Article 23, traffic in human beings include four things: selling and buying of women, men, children like goods. Okay, immoral traffic in women and children, including prostitution, and then Devdasi system they are prohibiting, and then slavery. So all these four things. So for punishing these acts, Parliament has made this Immoral Traffic Prevention Act of 1956. Okay, so Immoral Traffic Prevention Act of 1956 is in parallel with Article 23. Fine. Next. So now we saw related to traffic. So you can see here two terms I told you. So this Article 23 is prohibiting two things majorly. One is traffic in human beings. The other is Behar. So now we have discussed the definition for traffic in human beings. Now we'll discuss the definition for begar. So begar means compulsory work without remuneration. You can't just say compulsory work. Okay, if they give you work and they give you remuneration, that doesn't come under the concept of behar. Okay, so what happens is that I will tell you what is this bonded labor or behar is. Usually what happened, you would have studied in history related to the land revenue system, all the zamindari system, mahalwari system, all these things. So usually what happened, there will be a zamindar. Okay, so there will be a person who will go and get loan from zamindar. Okay, some amount of loan, for example, let's say 1,000 rupees. Okay, so what they will do is they will make a bond with this person. Okay, so according to that bond, if he is not able to give money back, he can work in zamindar's land. Okay, fine. So he will start working in the zamindar's land. But what will happen is that he can never be able to pay this 1,000 rupees, because the zamindars are one who is making this bonded labor process will ensure that their debt doesn't end at all. Okay, they'll put interest, they'll give food, for that also they'll charge from their work only. So they ensure that these people work throughout their life just to pay the debt what they have taken. Okay, so that is called as begar, that is called as bonded labor, or that is called as forced labor. Okay, so it was a peculiar Indian system by local zamindars sometimes to force their tenants to render service without any payment. So in addition to Behar, Article 23 prohibits other similar form of forced labor like bonded labor. Fine. So this is what is very important. Next, the word force includes not only physical or legal force, but also force arising from compulsion of economic circumstances. For example, there is a person who is coming and asking for job. Okay, so there is a employee, there is an employer. So this employer, what he is knowing that this person is very poor, he needs this job very badly. So instead of giving him 10,000, which is the worth of the job, he is just offering 5,000. This also comes under force. See this. It's not just not giving the wages, also working for less than the minimum wage. Do you understand? Less than the minimum wage if anyone is forced to do work because of the economic circumstances. If a person is employing such kind of forced labor, that person will also be punished under this Article 23. Okay, so in this regard, there are certain parliamentary acts. What are those? Bonded Labor System Abolition Act, Minimum Wages Act of 1948, Contract Labor Act of 1970, and Equal Remuneration Act of 1976. So these are the four important acts which is dealing with this forced labor. So forced labor is not just without remuneration, also less than the minimum wage. Okay, so these two things you should keep it in mind. Fine. Next. Article 23 provides for an exception to its provision. So what is this? It permits state to impose compulsory services for public purposes. So till now we saw that either state or a person cannot, cannot do this forced labor. But state under Article 23 has certain exception, that is for public purposes or during war or something, the government can make working for military or servicing in military a compulsory work. Okay, so that is exempted under Article 23. See this. So for example, it can be a military service or a social service. Now we know very well we have this COVID-19 situation. Okay, so now if government decides, the government is deciding that we want every citizen to work related to COVID-19 situation. So they should do social service. If this is an government order, we should obey it. Under Article 23, we cannot claim that it's a forced labor. Fine, that is what is important, which it is not bound to pay. Without remuneration, we have to work. Okay. However, in imposing such service, the state is not permitted to make any discrimination on the grounds of religion, race, caste, or class. For example, two situations I'll tell you. Situation number one. So in this COVID-19 situation, if the government is saying everyone should start working, everyone should do a social service. Fine, social service. This is right, constitutionally valid. But you know, the government is talking about talking that everyone should work except a particular caste, except a particular race, except a particular religion. Fine. So everyone, including religion, excluding the religion, it is constitutionally not valid. But you can note one more thing here. Here they have not mentioned sex. Can you see that? Religion, race, caste, or class, be very careful, guys. Here they did not mention sex because sometime during war, the government will ask only the men to come and service in the military. That time you cannot claim that this is a discrimination. Clearly, the discrimination has been given that it cannot be discriminated only on the grounds of religion, race, caste, or class, not on sex. So now if government is deciding every men should come and work for COVID-19 situation, it is constitutionally valid. Fine. So this is what is these kind of the slight important things which will become a twist, which can be asked as a question in the UPSC, should be very important. You should keep that thing in mind for sure. Fine. Next, Article 24. So Article 24 is especially concentrating on exploitation of children. So this Article 23 is generally exploitation, traffic in human beings and forced labors. But here in Article 24, they especially concentrate on employment of children in factories, etc. So here, what is the fundamental right? What is the Constitution saying? It prohibits the employment of children below the age of 14 years in any hazardous factory, mine, or works like construction work or railway. Fine, but this does not prohibit their employment in any harmless or innocent work. For example, there is a family business. So beyond that also, see, innocent work also should be beyond their study hours. For example, they should go to school. Morning 9 to evening 4 is the study hours. Beyond that, they can work for their family business or any innocent work, okay, which is not harmless for them. Okay, it's a very simple work, innocent work can be done. Okay, but spoiling the education of a children, or spoiling their health, or it's very hazardous in nature, they should not be allowed to work. Fine, that is the thing. The Child Labor Prohibition and Regulation Act of 1986 is the most important law in this direction. So you can ask, ma'am, is this the only law? No, there are certain other laws which are also equally important, like Employment of Children Act of 1938, Factories Act of 1948, Mines Act of 1952, Merchant Shipping Act of 1958, Plantation Labor Act of 1951, Motor Transport Workers Act of 1951, Apprentices Act of 1961, BD and Sihar Workers Act of 1966, and similar other acts prohibit the employment of children below certain age. You can see, okay, they are prohibited working in factories, they are prohibited working in mines, they should not work in merchant shipping, plantation labor, they should not be used as a plantation labor, not in the motor transport, automobile industries, they are not allowed. In Apprentices Act, they have certain conditions. BD and cigar workers act, they are prohibited in working in BD and cigar factories. Fine. So these are the important concepts. In 1996, Supreme Court directed the establishment of Child Labor Rehabilitation Welfare Fund. What is this Child Labor Rehabilitation Welfare Fund? So in this fund, what will happen is that the offending employer, so that is if there is a person who has child labor, he should deposit a fine of 20,000 for each child he has employed. That is, if a person is having 5 children employed, okay, so 5 children employed, then that person should pay 1 lakh of fine. They should deposit 1 lakh of fine in this Child Labor Rehabilitation Welfare Fund. This fund will be used for taking care of those children, like education, their livelihood, all these things. Fine. Next, the Commission for Protection of Child Rights against 2005 was enacted to provide for the establishment for a national commission and state commissions for protection of children rights, and children courts are also established under this Commission for Protection of Child Rights Act of 2005. Okay, for providing speedy trial of offences against children or violation of child right. So in terms of tea stalls or hotels, you would have seen no child labor has been employed here. Yes, it's been prohibited to employ the child labor in those places. Even sometimes what happened, they are employed there beyond their working hour to do some very small work, some writing kind of work. That sometimes is allowed below 14 years, but not hazardous works. Fine. So next. In 2006, government banned the employment of children as domestic servants, workers in public establishment like hotels, dabas, restaurants, shops, factories, resorts. So yes, see, tea shops, spas, and so on. Okay, so these kind of business establishments, they are banned. Okay, if it is a family business, and if a child is like going in the evening times just to help father or mother, when they are making some notes, then they are doing some calculation, that doesn't come under child labor. A child is there, has been employed there to do all the works, like cleaning the table, serving food, and then not going to school, then it comes under the child labor. That person will be punished. Even though it is your own son or daughter, that will come under the child labor if it is within the study hours and if you are making them do very heavy works. Fine, that is also very important. That should be very clear. Warn that any children employed below 14 years of age will be liable for prosecution and penal action. Child Labor Prohibition and Regulation Amendment Act of 2016 amended the Child Labor Prohibition and Regulation Act of 1986. It has renamed Principal Act as the Child and Adolescent Labor. Okay, it's not just child labor. They are naming it as Child and Adolescent Labor Prohibition and Regulation Act. It's not just prohibition, they are regulating also the kind of employment they are regulating also. Fine. Next. Next, coming to most important concept everyone should understand about. This part of fundamental right is making our country a secular nation. We do have the term secularism in preamble. We talk about secularism in terms of fundamental right implicitly, yes. But what is ensuring that we are a secular nation is this part of fundamental rights. Right to freedom of religion. Freedom of religion is a fundamental right guaranteed by the country's constitution, and the 1947 Modern India preamble state that the country is secular. Okay? Yes, every citizen of India has a right to peacefully promote, practice, propagate any religion. Okay? So before going to the right, see this, in secular India, the state is only concerned with the relation between man and man, but not man and God. Okay? When will state come into play related to religion? When the religion is having some impact in man and man relation, state comes into play. The state will not, enter between man and God. Okay, that is their personal opinion. But when there is a impact, between man and man because of religion, state will come into play, state will intervene, state will take actions. Fine. We'll see what are the articles related to that. Freedom of conscience and free provision, profession, practice and propagation of religion. Okay, freedom of conscience is your belief system. Okay, you can believe in any god you want to believe in. There is no control that state can make. State cannot say, no, no, you should only believe this God. The state cannot say, no, no, you should not pray this God. This religion is prohibited. This kind of thing state cannot say. And free profession, like, you can talk about that religion, you can practice that religion, and you can try spreading that religion. Okay, so that is also there. But this propagation, that is spreading of religion, conversion of religion, has some condition. We will see that. So before that, article 25 say that all persons are equally entitled to freedom of conscience. So freedom of conscience, right to profess, right, profess is preaching. Okay, you can teach people about your religion, you can practice your own religion, and you can try to spread your religion. But here forcible conversion do not come under the concept of freedom of propagation, because when you forcibly try to convert a person into religion, there you are affecting their belief system. For example, sometimes forcible conversion takes place because of certain condition. So number one, I'll tell you real condition, when will these situation take place. Okay, number one, for example, there are two people who want to marry each other, but they are in different religion. So implying a condition that you have to convert religion to marry, that is not constitutional. Okay, unconstitutional. Second, there is a person who is economically depressed. Economically depressed. So in this situation, you are forcing the person to get converted, promising some kind of economic things. So forcing, the person doesn't want to convert, but forcing to convert is against this constitution. From above, it is clear that Article 25 covers not only religious belief but also religious practices, rituals. There are certain rituals which are superstitious in nature, which is harmful to the society. Okay, so for example, we know very well about sati. Sati is one important example. We can, sati has been abolished very long back, but still I'm giving you an example how ritual can be harmful. Okay, so these kind of things are important. So this right is available to all person, citizens and non-citizens also. Fine. However, the rights are subject to public order, morality, health and other provision relating to fundamental rights. If religion or religious practices, that is belief systems or rituals, if both are disturbing the public order, if both are disturbing the morality of the society, if both are disturbing health of the society, health of individual, and if it is coming in between other fundamental rights, then this right will not be available to a person. Fine, very important. Next, for the state. So now, what state can actually do in terms of religion? Okay, we'll see. State can restrict any economical, financial, political or other secular activity with associated with religious practice. So they can either restrict or regulate. Both state have power with. Okay. Provide for social welfare and reform or throw open Hindu religious institutions of a public character to all classes and sections of Hindus. So you can just see here they are talking about Hindu religious institutions only. So the government has power to give social welfare or reform by opening Hindu religious institutions for public to all classes and sections of Hindus, various sections of Hindus. Fine. And Article 25 has two important explanation, very important, listen to this. One is wearing and carrying of kirpans. Kirpan is like a sword, okay, in Sikh community, they have that kirpan with them. So one is this carrying of kirpan is constitutionally valid and it is included in the profession of Sikh religion. Number one, profession is like what is the preaching or following that rules and regulations. Number two is here Hindus. So here we spoke about Hindu religious. Okay, Hindu is not the literal meaning of Hindu alone. It includes Hinduism, Sikhism, Jainism, and Buddhism. So what does that mean? If there is Sikh institution, if there is Jain institution, if there is Buddhist institution or Hindu institution, these four institutions can be opened by the government for general public. Okay, so that is what is important. Next. Next is Article 26, freedom to manage religious affairs. So what is this freedom to manage religious affair under Article 26? Under Article 26, what are the freedom we have? Right to establish and maintain institutions for religious and charitable purpose, for not for economical purposes. We can establish and maintain institutions, religious institutions for religious and charitable purpose. Fine. Right to manage its own affairs in matters of religion. So I told you already, the state will intervene only between man to man relation, not man to God relation. So the state will not come under managing the affairs related to religion. And right to own and acquire movable and immovable property. That charitable, that religious institution can own a movable and immovable property. And that property can be administered by that institution only according to law. Okay, they should follow law and then they can have their property. Next, this question is important. When will you call a people? When will you call a community that it's a different religion? What is religious denomination? So it should satisfy three conditions. So what are those conditions? It should be a collection of individuals. Sorry. It should be a collection of individuals who have a system of beliefs which they regard as conducive to their spiritual well-being. So there are people who believe that, there is a group of people who believe that their belief system is very, very important to maintain their spiritual well-being. Number one. Number two, they should have a common organization. Fine. Next is, it should be designated by a distinctive name. You can't just call with other religious denomination name. Okay. So in this situation, the Supreme Court held that Ramakrishna Mission and Ananda Marga are religious denomination within Hindu religion. Okay, so within Hindu religion, they are religious denomination, but Aurobindo Society is not a religious denomination, because when you see Ramakrishna Mission and Ananda Marg, they have this, they have their own belief system, uh, which is within the Hindu religion, and they have a common organization like Ramakrishna Mission and Ananda Marg, and they have a distinctive name. Okay, but Aurobindo Society do not have a belief system which is related to their spiritual well-being, so they cannot be called an individual religious denomination. Next, Article 27, freedom from taxation for the promotion of a religion. So what is this? For promoting religion, taxation is relaxed but not fee. Keep that in mind. This term is very important. See this statement. For promoting a religion, it can be any religion. For promoting a religion, see, this is what the secularism mean. They are not talking about one religion or two religion. In general, for promotion of religion, tax cannot be levied. Fine, they need not pay any taxes, okay, or religious denomination. But the provision prohibits only the levying of tax, not a fee. For example, for pilgrimage, when people are going for pilgrimage, they get some fee. So why this fee is there is, it is to control secular administration of the religious institution and not to promote or maintain religion. Okay, so the fee is brought. For example, you're going for some darshan, there some fee is levied. Why? To maintain that, maintain that organization, the fee is levied, not for promotion of that religion. Okay, so that is the clear idea. So taxation is not there, but fee is there. That fee also is not for promoting any religion. That fee is just to maintain, to control the secular administration of that religious institution. Fine, not for the religion. Secular administration means, for example, paying the salary for the people who work there, or education related activities, charitable functions, charitable related activities. They can use that money, but not for promoting the religion. Okay, so that is the important thing. Next, Article 28. See, very important thing. So in Article 28, what is the major thing is freedom from attending religious instruction. That is, it is the citizen who decides whether he should attend a religious instruction or not. Okay. For example, I'm studying in an educational institution. That educational institution will have a prayer. Okay. I should only decide whether I should attend that prayer or not. But it's not for all educational institutions. There are certain conditions where you don't have this right. You have to attend the prayer. We'll see what are those conditions. Fine. Okay. See, I will not accept this fact that India have a funny constitution. Satisfies, it gives a peaceful life to many of their citizens, most of their citizens, and when it is unconstitutional, they try to stop it. Okay, this is how our Indian constitution has been designed. If our Indian constitution has not been designed in this way, I'll tell you what will happen. We would not have been living in harmony. Okay, we would have been dominated by any community, any stronger community, and today we won't be republic or democratic nation. Okay, that is what I'll tell you. Fine. So for this you should have a proper understanding of Indian constitution. I will not tell that Indian constitution is 100% perfect. There are certain setbacks, but still those setbacks are amended in future. Those setbacks are taken care by the Supreme Court, and this is keeping on evolving from time to time. That is how it is. Fine. Under Article 28, no religious instruction shall be provided in any educational institution. This here in its educational institutions. In any educational institution wholly maintained out of state funds. That is what is the thing. So government schools. In government schools, you cannot make the prayer compulsory. Number one. Number two, this provision shall not apply to any educational institution administered by the state but established under endowment trust. Okay, so this is what is very important. Under endowment trust, if there is any government school or state using the state fund, if there is any schools under endowment trust, there this right does not apply. Okay, so there it is made compulsory that they should attend the prayers. Don't worry, just listen. Finally, I'll summarize so that you will understand even more. Next, for example, if there is a person in any educational institution, not just schools. So, in educational institutions, what will happen is that if there is a person who is a major, he can decide whether he should attend the religious instructions or not. If in case of minors, if in case of school going children, the guardian should give permission to attend these kind of religious instruction. Okay, if guardian is not having any problem, the child can attend the religious instruction. But if guardian does not believe in religious instruction, or if guardian has any objection in the child or the minor attending religious instruction, then there comes the question of Article 28. Fine. Next. There are four types of educational institution. This is what I told you. I will summarize finally. There are four types of educational institutions. What are those? First is institution wholly maintained by state. So usually the government colleges, government schools come under this. Government schools and colleges. Fine. Next. Institution administered by state but established under any endowment or trust. Okay, so it is administered by the state. Okay, the employments are made by state, all these things. But under which it was established is, it is established under endowment. Endowment means it's a it's a wing, it's the organ of government which takes care of religious activities, endowment or trust. Next is institution recognized by state. Okay, institution recognized by state, it's a private institution but has got the approval of state. So most of the private institutions come under this concept. Okay, this C. Okay, it can be a private school or private college. We know very well, without the recognition of state, they cannot have a proper institution. D is institution receiving aid from aided schools. We call it as aided school. That is, there will be a private, there will be a trust, private trust, and they will be getting aid. Aid is some help for some kind of fund from government. So first is completely governed and funded by the state. Government schools and colleges come under this concept. And then endowment. So endowment is, the state is administering it, but it has been established under any endowment or trust. Third is private organization but recognized by state. And fourth is institution receiving aid from the state, that is government aided schools and colleges. Fine. So what will happen these places? For institutions wholly maintained by state, religious instruction is completely prohibited. Can you see, in government schools and colleges, you have morning prayer. In that you will be seeing secular words used, secular songs or secular things used. Okay, like value added songs. These kind of instructions will be there, but not religious instructions. Fine. So religious instruction is completely prohibited. Okay, yes, right, recognized means accredited by UGC, all these things. Okay, the government organizations, government organs should recognize them. Fine. Next is in B, this is institution administered by state but under endowment, their religious instruction is permitted. Okay, according to which endowment? It can be Hindu endowment, it can be, Jainism, it can be Buddhism, anything, their religious instruction is permitted. In C and D, that is either private organization recognized by state or government aided institution, religious instruction is permitted on voluntary basis. That is, the students who are studying there can decide whether they have to attend the religious instruction or not. Okay, so first, completely under government, no religious instruction. Next, under government but under any endowment or trust, religious instruction is permitted. Next is any private institution or government aided institution, they can conduct or they need not conduct any religious instruction. At the same way, the students can decide whether to attend the religious instruction or not. This clear idea is very, very, very important. Fine. So any doubt in whatever we discussed today? So fundamental rights is not over today. We have few more fundamental rights. We will study in the next class, cultural and educational rights we have. And finally, the most important, right to constitutional remedies. After that, we'll be doing some comparisons. Next class is also very important to people because the most important points are there. Fundamental rights, starting from the first point to the last point, every point are important. You cannot expect a question paper without anything related to fundamental rights. Okay, every year you take a question paper, at least one question you can expect from fundamental rights. It's very rare that you don't get a question related to fundamental rights. Related to fundamental right doesn't mean just article. Anything related to fundamental right, all the parliamentary acts related to fundamental right comes under this. Fine. So thank you so much. If there is any doubt, please do comment. I will help you with your doubts, and use the link, all these things. Yes, today ethics topic is uh, okay. So today's ethics topic, we'll be discussing about family and educational institution as the source of ethics. How family and educational institution act as the source of ethics. Today's most important topic. We'll be getting more interesting and important concepts for UPSC exam, mains examination. Fine. So thank you so much. See, people don't think that you have 10 more months for the next attempt. Don't be lethargic. When you don't work from now, it's very tough. on that prelims day. Fine. So I always tell my students, I always tell you people, the selection process starts from your preparation time, not from the prelims. The actual UPSC selection process starts from your preparation time itself. They will know if you are fit for UPSC, if you are fit for civil services or not from your preparation strategy itself. That is how the question papers are set. Okay, so prepare properly. All the best to you all. See you in the afternoon. From today onwards, we'll have more important concept in special classes. Do not miss special classes. Come to my special classes. You can come to my profile in Unacademy profile and you can just see what are all the special classes we have. Okay, so thank you so much. Happy meeting you all. See you afternoon. Fine, thank you. And use this code SUBA Suba to get the 10% of discount. And like this video, share this video. As I tell you, when you share your knowledge gets increased. Fine, so do that. We'll all meet in the afternoon. Thank you. Bye bye.